A federal judge has stopped the ban of gender-affirming treatments for 3 transgender youth whose parents have sued the state. Let's talk about it. Hey everybody, it's Dr. David. So in this video, we're going to talk about the definition of bigotry, why a federal judge stopped the state of Florida from banning the gender-affirming treatments for these individuals, why the judge feels that it's likely unconstitutional what Florida has done, and also how the judge has implied that this is actually an act of bigotry. Okay, so let's first talk about what the definition of bigotry is. Now, I do point out that there could be acts of bigotry, bigoted thoughts. It doesn't necessarily mean that a person as a whole is a bigoted person. We are led often by our past, by our families, by our community, things that may have been exposed to us or fast. And part of the reason I'm doing these types of videos is to make people realize that maybe that the types of behaviors that they're participating in, the things that they support, if they take a step back, maybe they would realize, hey, I'm hurting other people by this. So that's the premises, and that's very much a part of the educational component of what I'm trying to do as part of this channel. Okay, now, as far as the definition of bigotry, and I am going to be referring to my notes a little bit more because there's more legalese as opposed to medical conversation, and I want to make sure that I get this all right. So the definition of bigotry: an obstinate or unreasonable attachment to a belief, opinion, or faction, in particular prejudice against a person or people on the basis of their membership of a particular group. So in this particular case, the particular group are people who are transgender, in particular those who are wishing to undergo care as a minor. Okay. Of course, there are other transgender laws and other LGBT laws that have been passed in the state of Florida that probably will fall under this other, as part of this definition as well. But we're just going to be focusing on this particular issue, especially as it relates to children. As a pediatrician, I stand up for children. I have patients who may be interested in these types of treatments as they're figuring out who they are as part of their gender identity. Okay, so now a little bit of a background. Okay, 7 families sued the state of Florida because they felt that their rights were being impinged in terms of making a medical decision for their family, and 3 of those families were granted the right to proceed immediately. It is not clear to me at this point as to why the other 4 were not. It may have something to do with the urgency of the matter of the need to start this type of treatment relative to where the youth are in their puberty path, if you will. But we do know that there are these 3 particulars. Now, the judge also has said that denying their care to accessing the puberty blockers and the gender-affirming hormones would cause irreparable harm. Okay, and Florida is indiscriminately banning the treatment for indiscriminately banning this treatment for gender dysphoria. Okay, now this is a 44-page scathing article by U.S. District Judge Robert Hinkle. Okay, he's the one who put this forth. This is an actual order. This is something that is the law as of right now. And he said that those who support the ban of gender-affirming hormones or gender-affirming treatments for transgender youth are acting out of anti-transgender bigotry. Okay, and the judge determined a decision for these 3 patients at issue cannot wait for further or better research. The treatment decision must be now. So that's kind of why I'm assuming that there may be something different among these 3 versus the other 4 based upon that comment. Now, until a final judgment is put forth for this entire lawsuit, it enables these 3 children to proceed, but not everybody else who may be impacted by this. Okay, this is specific to these 3 individuals. Now, if you want to do an interesting read through the full ruling. It's really quite remarkable, and I put a link to it in the show description down below so you can see for yourself. Now, one of the things that the judge made a comment on, a real distinction, is dispelling the myth that transgender individuals are choosing the gender they want to be, and says the following by the judge. With extraordinarily rare exceptions, every person is born with external sex characteristics, male or female, and chromosomes that match. As the person goes through life, the person also has a gender identity, a deeply felt internal sense of being male or female. For more than 90%, 99% of people, the external sex characteristics and chromosomes, the determinants of what the judge is calling a person's natal sex, like we talk about prenatal, natal, birth, and natal, which is another way of saying birth sex, matches the person's gender identity. For the less than 1%, the natal sex and gender identity are opposites. A natal male's gender identity is female or vice versa. Gender identity is real. The medical defendants, so in this particular case, who are being sued, is the Florida Surgeon General, the Florida Board of Medicine, and the Florida Board of Osteopathic Medicine. They are the defendants here. The defendants, speaking through their attorneys, have admitted as such. Gender is real. Gender identity is real. Now, let's talk a little bit more, because he does reference gender dysphoria, which is something we've talked about before, but also specifically that this is a recognized medical condition. Okay, it's a diagnosis. It's a psychiatric diagnosis, because of the dysphoria, that is defined in the DSM-5 manual. That is the main text, the real text that all psychiatric mental health conditions are listed under, with particular codes and how it is specifically diagnosed. So there's checklists and stuff that make it. It's not just somebody says, I'm gender dysphoric. There is an actual question, just like there is for autism, just like there would be for schizophrenia, major depression, etc. And these standards are what is used by health insurance companies when it comes to coding, as well as by the U.S. Department of Health and Human Services. Now, the overwhelming weight of medical authorities, medical organizations support the treatment of transgender patients in appropriate circumstances. Yet the state of Florida claims that these major medical organizations, the Academy of Pediatrics, the American Medical Association, the American Psychiatric Association, the Psychological Associations, all of these people like us who are experts, trained in these types of diagnoses and caring for people. Florida is saying that all of us, that we have it wrong, and that they're dominant, and that these organizations are dominated by individuals who pursue politics, not good medicine. But the judge counters that by saying, where there is bigotry, there are usually, one hopes, always opponents of bigotry. It is hardly surprising that doctors who understand that transgender identity can be real, not made up, doctors who are willing to provide supportive medical care, oppose anti-transgender bigotry. If ever a pot called the kettle black, this is it. The statute and the rules, what we're talking about, were an exercise in politics, not in good medicine. Now, furthermore, we go on to have the conversation about that the Florida law, as written, violates Equal Protection Clause. Stopping a person from conforming to the person's gender identity is not in the legitimate state interest. So the judge is saying, if a person chooses to do this, this has nothing to do with the state. It's not in the state's best interest to have a law such as this. It's not helping the state. It's not helping the community. The only people who are being impacted is the individual and their family. The judge quotes a Florida Department of Health fact sheet, which states social transitioning, which involves no medical interventions at all. This is like talking about gender pronouns. This is talking about how people dress, accessorize, how they want to be called. Okay, that social transitioning, which involves no medical intervention at all, should not be a treatment option for children or adolescents. So obviously this has nothing to do with saving the children, that the children are being harmed by this. They're talking about just even this type of social transitioning. And the judge then says, nothing could have motivated this remarkable intrusion into parental prerogatives, parental rights, remember that part, other than opposition to transgender status itself. Okay? Now, the Florida law, he claims, also violates due process clause, because protecting a parent's right to control a child's medical treatment, that in of itself is a protected right. A parent has a right to choose their medical treatment. Informed consent, the gathering of pros and cons, benefits and negatives in order to decide what's right for the individual. Of course, the individual consents. Of course, the doctor has to provide the medical plan and agree as well. But that itself, a parental right, medical freedom. Now, Florida law, he says, also ignores the benefits of transgender care, such as these hormones. The judge says, the statute ignores the benefits that many patients realize from these treatments. and the substantial risk posed by foregoing the treatments. The risk from failing to pursue what is for many the most effective available treatment of gender dysphoria. The judge actually goes on to describe a patient that's involved in another Florida case who attempted to commit suicide 4 different times, okay, before beginning the successful treatment of the gender affirming treatments. Now this person is thriving. So he goes on to say, specific case about how somebody was almost killed themselves because they didn't have the care, and now they're doing well with it. So is that what's in the best interest of the state? People committing suicide, having more expenses for anxiety, depression? Of course not. The interest of the state should be making sure our citizens are happy and healthy. Okay. Now, the judge then concludes with by saying that if these 3 plaintiffs, in this case, do not start hormone blockers soon, they will go through puberty consistent with their natal sex. They will live with the consequences for the rest of their lives. That's pretty impactful. Now, this is also how the judge is implying that this law is based in bigotry. Okay. Now, when courts determine that the state doesn't have a legitimate interest in a law, the court often tries to identify the government's motivation. What's the motive in passing this type of law? They'll look into the legislative record. They'll look to public statements by the officials, etc. And the judge says that that Florida itself in the case has offered no evidence of any resident in the state of Florida who regrets being treated with puberty blockers or gender affirming hormones. So this other part of the law, which we're not talking about today, where the individuals can sue the doctor if for performing these types of treatments later on. Okay, that's what the law now says, but this has never been a problem in the state of Florida. This is a solution looking for a problem because it doesn't exist. Okay, the judge then said, there has long been and still is substantial bigotry directed at transgender individuals. Common experience confirms this, as does a Florida legislators' remarkable reference to transgender witnesses, people, at a committee hearing when he referred to them as mutants and demons. This was a Florida representative referring to his own citizens as mutants and demons. That's bigotry. Just because they're transgender, he's assigning these things to them, these horrible, horrible things to them. It's terrible. Okay, so now overall, while this ruling, as I said, doesn't apply to anybody besides the 3, it does set precedents. Okay, very well spelled out. This will be used in the future. I'm sure that there will be other lawsuits that will follow. Hopefully this will get to a point where this will be outlawed altogether in terms of the banning of would no longer be a thing and individuals can proceed with their gender affirming care in the way that they see fit, the way that their family sees fit. Now, did he apply that the law is bigoted? He certainly did. You heard me saying it over and over here. And he addresses the whole thing and says that, the apparent bigotry, the malice behind this law, because that's really what it is. It's malice. It's not helping anybody, and that's what malice is. So really, the state put together a law that, according to the information that we have, doesn't help any citizen. It hurts citizens, and it's bigoted and prejudicial against these people. Hope you have some food for thought there. Have a nice day.